Guys, the news is nothing but court case after court case. There is no way to keep up. Fortunately, I am here with my trusty coffee to break it all down for you. Happy Tuesday, everybody. I'm Brian, and this is the Morning Report on the federal courts for August 19th, 2025. As usual, if you wouldn't mind, drop a comment or a like and watch to the end of the video if you can make it. It really helps get this thing out there. Now, I'm going to do an overview at the end of all of the active voting rights cases, so stick around for that if you can make it. Okay, right out of the gate, we have New Jersey v. Department of Justice, a new case that was filed yesterday by a bunch of states directly against the Department of Justice, and this may be one of the ones we remember. Now, the Trump administration has found itself hampered by federalism, things that the federal government isn't allowed to force states to do, but the president wants to force the states to do. So instead, he's been withholding lots of federal money until states agree to implement his programs willingly. And this has sort of been his strategy across the board. Well, the states seem to be fighting back against this, and they've chosen a hill to really start this fight on: the 1984 Victims of Crime Act. Now, this act, like it says in the title, gives money to victims of crime, helps pay for funeral expenses, helps shield witnesses, pays for forensic exams, that sort of thing. And this money is authorized directly by Congress, but the president's job is usually just to distribute the money, usually like to cut the checks, essentially. But the president is holding on to the money unless the states agree to change their local immigration laws. And in this case, the states are saying enough. Now, I think there are about 19 states here, plus DC, who have all come together and are suing the Department of Justice and demanding that these grants are paid without condition. So the complaint was filed yesterday. This is a brand new case, but I want to make you aware of it. I think this may be one of the bigger ones. This may be one of the ones we remember in a few years. Just a guess. Okay, now we're going to hit an Elon case. This is Doe v. Musk, and there are a few of these floating around. This one is a USAID case brought by a bunch of laid-off USAID employees who were challenging their terminations at work. And the court issued a preliminary injunction in this case, at least stopping the terminations for now. But that injunction was paused by a stay while part of the case is appealed. I know, it's a pause of a pause, which is, but bear with me. Well, in the meantime, there's some good news for most of the employees who theoretically may be protected by that injunction if it is unpaused. Yesterday, the court explained that it would be certifying most of the class for a class action in this case. The court had to decide which plaintiffs it was going to allow into the group of plaintiffs, and I assumed it would cut out everybody who wasn't a fully vested employee. But it turns out they included almost everyone that worked there, including, surprisingly, personal service contractors, who I really didn't think they'd include. Now, it doesn't mean they'll all win, but if the injunction is reinstated, then they would all be protected while the case is being decided, and that's something. Unfortunately, because this is a constitutional claim, non-citizens who live in other countries are not going to be included in the class. So if you work for USAID and you were a German citizen who lived in Germany or somewhere outside of the US, you will not be part of the class. So they will not be protected by the injunction, but everybody else will. So if the stay is lifted and the preliminary injunction comes back, all of those people's jobs will be protected at least for a little while. So good news for some people. All right, next we are going to hit up a case with a name that I cannot pronounce. This is Woonasquatucket River Watershed Council v. Department of Agriculture, Woonasquatucket. This is a federal funding case where billions in federal funding is owed and the Fed is just not paying, but woo, you guys. So this is a Trump-appointed judge here who released this statement, and she is not happy. I'm going to quote some of her statement with a little paraphrasing to save time, but if you hear some crazy language, it is her, not me. So she issued a preliminary injunction in April stopping the government from withholding funds. The court and the parties then had to have 4 status conferences over the course of 3 subsequent weeks to wrangle the government into compliance. The government assured the court that HUD had resumed processing the money, but the next status report says otherwise, to the tune of $760 million already awarded funds for low-income senior housing still inaccessible. Low-income senior housing, ooh. At risk of an understatement, this is serious. If no comprehensive funding has been processed in the nearly 4 months since this injunction, the court struggles to see how HUD's inaction can be construed as anything other than a serious violation of the court's order that exhibits blatant disregard for it. She said that the government is entitled to explain itself and shall file a response including specific action it has taken to move forward since the April order. So they're supposed to have a follow-up status report on August 27th. We will keep an eye on that one. All right, now we're going to move into the world of voting law for a few, and we're going to start with a case out of Louisiana called Nairne v. Ardoin. Pardon my French. This is a Louisiana case that was filed in 2022 and challenged Louisiana's new redistricting plan after the last census, claiming that it violated the Voting Rights Act by drawing congressional lines aimed at discriminating based on race. And the district court in this case agreed. Yeah, this map is discriminatory, but Louisiana appealed. Well, on Friday, the Fifth Circuit Court of Appeals affirmed the lower court's decision that the new maps did, in fact, violate the Voting Rights Act and would need to be redrawn. Now, the test to establish a violation under the VRA is insanely complex. You have to meet the requirements of 3 preconditions. I think the second precondition has 4 parts. Then once you've met the 3 preconditions, you have to go through a 9-part balancing test. So if you want to see some real common law in action, I put a copy of this opinion in my shared documents in the subject matter library under voting rights. It's a doozy, but it's a heck of a read. Break out your highlighters or post-it notes. It's tough, but it's an interesting demonstration of good old-fashioned common law if you want to see it. Okay, last thing, a lot of people have asked me about this new executive order related to voting rights. Now, guessing how an EO is going to be used with this administration, very hard to do. So I'm going to wait for the inevitable cases to be filed. We'll talk about it then. But in the meantime, I thought now would be a good time to do a quick refresher on the 4 voting rights cases that we've had so far this year. Now, remember, the federal government, as a general rule, is not involved in making decisions about actual voting rules, and that's what a lot of this is about here. So we're going to start with DNC v. Trump. This was about an executive order that said that all executive branch employees had to follow the president's and attorney general's legal interpretations of the law. So the DNC sued because the Federal Elections Commission have their own lawyers, and they shouldn't be following the president's interpretation of the law. They should be following their own. And this case was ultimately dismissed because the FEC lawyers came in and said, yeah, we saw the executive order and promptly ignored it. We are not executive branch employees. We don't follow the president's orders. So the court dismissed this one, but without prejudice, meaning that the case can be brought again if there's any evidence that the FEC isn't sticking to what they said they'd do. The other 3 cases are all about Executive Order 14248, which basically says a bunch of stuff about requiring proof of citizenship for voters. And the real issue here isn't that it requires proof of citizenship, because at some point in the process, most, if not all states, do require proof of citizenship. It's just not always done in exactly the same way or exactly the same time. The problem is that the Fed just isn't allowed to order states around on voting issues like that. So we have 3 cases. The first is LULAC, which is brought by a group of organizations, but more importantly, as we'll see in a second, it's brought on behalf of individuals in those organizations. Now, LULAC sued to stop the executive order and filed for a preliminary injunction to stop what the judge saw as 2 categories of behavior by the federal government. And those 2 categories turn out to be pretty helpful, so we're going to go ahead and use them. The first category was individual harm to the members of LULAC and the other plaintiffs, like people being purged off voter rolls or being refused copies of a certain voter-related form. The second category was more systemic harm, things like the federal government refusing to send grants to a state government unless the state agreed to certain voter restrictions. And the judge said, okay, I'm going to give you the preliminary injunction for the individual harm category. That seems like a good idea. But I'm not sure you're the best plaintiff to bring the institutional harm category, especially since we already have these other 2 cases that I'm about to talk about, which were brought by state governments. So the judge said, I'm not going to give you those. We'll let the states defend themselves on that stuff. So that's where LULAC stands. They have a partial preliminary injunction. Then we have these other 2 cases brought by states. Washington v. Trump is brought by the states of Washington and Oregon. California v. Trump is brought by 19 other states, and they're almost exactly the same case. Washington v. Trump apparently realized they were sort of doubling up, but rather than try to join the other states, they tried to join the LULAC case for some reason. And the judge said, this doesn't seem like a natural fit. I don't know why they didn't then try to join the other states, but they didn't. So now we have 3 cases. Both of these other cases were granted preliminary injunctions for the institutional category things that LULAC was denied. But because of the CASA case, the Supreme Court case I keep talking about with the limiting injunctions, the injunction is limited to protecting only the plaintiffs in these cases. So it protects the citizens of those 21 states. But if you live in Idaho, for example, you're out of luck. So that's mostly where we are right now. Individual injunction in LULAC, institutional injunctions for the states listed in Washington and California v. Trump. And then one last thing, and I promise we're done. California v. Trump with the 19 plaintiffs has been appealed, and the court issued a stay during that appeal. Another one of those like pause of a pause things, so we're gonna have to wait and hear what the Court of Appeal says on that one to see if the preliminary injunction will be unpaused. Okay, you are now up to date on all of the voting rights cases going on right now, unless I missed one. I hope not. And it sounds like we'll probably get another one pretty soon. All right. That, my friends, is your Tuesday morning report on the federal courts for August 19th, 2025. Again, leave a comment if you can. If you're interested in supporting me or my work, now would be a good time. Could really use it. There's a link in my bio with some other support options. I very much appreciate it. Quick thank you to Maxwell, Susan, and Brennan for the Venmos. Otherwise, keep watching, everybody, and I will keep going. Thanks a lot. Have a fantastic Tuesday. Thanks, everybody.